speak in public. It's the biggest fear thing we have. My name is Marlon Chaplin. I live at 1102 Oakview Lane, Genoa. And I've been a realtor for 33 years. I have problems when people try to continue to restrict the use of properties. One of the things in the broker classes that always talked about was the right of your property and what you can do with your property. So I'm addressing basically the use variation. How many in the county are there? Called, you know?
How many what?
How many would qualify for that?
I don't know, because it's not simply a matter of how many lots are less than 40 acres in Zone A1. It's also a matter of when were those lots created, and when were they purchased, and what kind of price was paid for them.
What would the price issue have to do?
The price issue is use variations when they were first adopted by the county in 1993. The entire reason for having that set of regulations is people said, look, you pay X amount per acre for farmland, but you pay more when you can put a house there. Okay, so I bought this piece of land, less than 40 acres, and I paid more because I knew I could put a house there. Now the county is considering, in 1991, telling me I can't put a house there now. The hardship is financial. We came to call that difference in price between regular farmland price and the cost of land where you can build the premium price, and it became one of the major issues.
Well, is that going to change now?
If the use variation are eliminated, it changes, yes. You either have 40 acres and can build a house in the A1 district, or you don't have 40 acres and cannot.
What about the existing parcels prior to 1976? And there were about 7 of them in the Franklin Township, Genoa Township, and Kingston Township area when I looked it up.
If this use variation provisions are in fact eliminated from the county zoning ordinance, those would not be buildable lots. You could not build a house on them.
So is that removing that person's property rights?
Only if they met that criteria in the first place.
So
And
the
by
answer
the
is
way,
yes.
no, it's not. It's not yes, because there's a misunderstanding of property rights. The fundamental misunderstanding comes from your initial statement about people having a right to do what they want with their property. In the United States, we have property rights because government says we have property rights. Our government that we elected, that we created, that we set up, gave the right of government to say that. In other countries, in dogmatic countries, you don't have those rights. We do in the United States because we have a form of government that says we have those rights. But we've never had the right to do whatever we want, wherever we want, whenever we want. We've always had rules and regulations. That's what zoning is. And since the 1920s, the Supreme Court has said zoning is legitimate exercise of government in the public interest. So to predicate your statements on the notion of there used to be a time when we could do whatever we want simply isn't true, and it's never been true.
Well, apparently in this county it isn't times, because there are parcels that have 25 cars on them that are junk sitting in the county, and the county takes no action against them that I'm aware of. But you're talking about taking rights away from other people.
I would invite you to come and talk to us about that. We deal with that frequently.
Okay. That's all I have. Thank you.